All rise. The Honorable Court of Appeals for the 7th District, Texas.
Please be seated. Our court clerk, general counsel, cautioned me that he laid a bunch of wires up here and said, Quinn, do not pull them out. So I've got to proceed carefully or else somebody will get mad at me. We want to welcome you to the Wednesday, October 4th, 2023 setting of the 7th Court of Appeals, sitting at Texas Tech University School of Law. We do want to thank the law school for allowing us to journey a little bit southward to Lubbock to hold oral arguments here. We appreciate the opportunity to maybe get involved a little bit in the education of the students who are watching so they can see a court in action, so to speak, and not just read about them in their books or watch them on TV or things like that. Coming down here is something that we really do enjoy. We do appreciate the lawyers, too, that come down here from out of town. I know that we have several from Dallas here and that we have some from Amarillo and more rural parts of Texas, but traveling down to Lubbock is very much appreciated. And again, you're part of that educational opportunity too. Not just the judges will be watching you, but you've got all these young eyes watching you going, is that what I want to be like? Or maybe I can learn from them or something along that line. So keep that in mind, okay, when you're doing your presentations too, please. Help them become better lawyers as well. With that said, we have two cases for this morning. We will take a break between the first and second in order to change panels. But before we start, I would like to ask the panel to introduce themselves. And I will start matter seniority. I'm not being disrespectful, but matter seniority, I'll start to my left.
I'm Judge Larry Doss. I have been on the 7th Court of Appeals since November of 2019. I'm a graduate of this law school, graduated from undergrad at Baylor, and glad to be here.
And to my right.
I'm Judy Parker. I've been on the courts for 6 years. Prior to that, I was on the trial court bench here in Lubbock. And I'm glad to be here today, a proud graduate of Texas Tech University School of Law, and it's always great to come home.
Very much so. One of the judges, our newest judge, is on the second panel this morning, Alex Yarbrough. He will be here again for the second panel, but I just wanted to mention him as well. To the far right, I will let our court clerk, general counsel, introduce himself, but don't mention the law school you went to.
Hi, I'm Bobby Ramirez. I've been with the court since 2015. I went to Tech undergrad and a law school in Austin. That work?
He learns how to fudge. He's our general counsel. He learns how to get close to the edge, but still do okay. My name is Brian Quinn. I'm a 1981 graduate of Texas Tech University School of Law, and again, I'm pleased to be here. With that said, we'll go on and call the docket. First case we have is 07-22-00231-CR, Humberto Saul Mendoza Rodriguez versus State of Texas. Mr. James Johnson was scheduled to argue for the appellants, but he has been called away for a trial, and he obtained someone in his stead who is a very learned counsel. Who's representing the appellant?
David Martinez, representing Humberto Saul Mendoza Rodriguez, Your Honor.
Okay, and Mr. Martinez, you're ready to proceed, correct?
We're ready to proceed, Your Honor.
Okay, and where did you go to school?
I went to law school at Texas Southern University, graduated undergrad from University of Nebraska, but I'm a local boy. I was born and raised in Slate. I've tried many cases. tried some cases with Judge Parker. I tried one case with Lawrence Dawes where we were on opposing sides. I never got to try any cases with Judge Quinn because he's been on the bench forever. He's been bench since 81. Is that correct, John?
I graduated in 81, but no, that's okay.
It's felt like he's been on the bench since 81.
I got my license November 12 of 1979. So I do a lot of criminal law, family law, personal injury. I can try criminal cases, but usually.
Thank you, counsel. That was almost a commercial, but that's okay. I appreciate that. And representing the state?
My name's Michaela Key. I am actually a Texas Tech graduate. I graduated in the wonderful year of 2020. So this is one of my first times arguing in front of appellate court, and I'm happy to be here.
What is the office you represent?
Oh, I represent the state of Texas. I thought we were just...
No, it's okay. Okay. What district? What district? District attorney?
I'm in the 287th Judicial District, so I'm up by Muleshoe, Texas, and Farwell, Texas, up by the border.
Very good. And this is your first time to argue in front of us, correct?
Yes, Your Honor.
Very good. We will do as best we can.
Okay, be
in
nice.
asking questions. Be nice, okay? Sometimes we say fresh meat, but we will attempt to be nice.
Objection.
You didn't object last time I said that. Come on. But with that said, you've been both admonished about the amount of time you have, 20 minutes each side, and then, of course, the appellant has a 5-minute rebuttal. You don't have to reserve any time. I know Mr. Martinez has argued in front of us before, and he knows that. And we are prone to ask questions. Answer them the best you can, and if you cannot answer them, you don't know the answer, please be candid and let us know that. We can always do research ourselves, too. Okay, with that said, Mr. Martinez, you have the floor.
May it please the court, counsel. Humberto Saul Mendoza Rodriguez was convicted in the 287th District Court of Palmer County for the state jail felony
Hold on a
offense.
second. Can you hear him? Thank you.
For the state jail felony offense of driving while intoxicated with a child passenger under age of 15. He pled guilty to the indictment after the trial court had denied his motion to suppress. And he had elected to have the jury decide punishment in this case. And the jury returned a verdict of 6 months in the state jail division of the Texas Department of Criminal Justice Institutional Division. Humberto Saul Mendoza Rodriguez was living in the city of Friona, Texas, which is about 80 miles due northwest of Lubbock. And he was driving an older vehicle, 2005 Nissan pick-em-up, and he was pulled over by a local law enforcement officer from the Friona Police Department. The issue in this case is regarding the warnings that are prescribed by the Transportation Code in the state of Texas before submitting or asking a person that has been arrested to submit to a breath test. The Transportation Code 724.015A specifically provides that certain statutory warnings are to be given to that individual. And in this particular case, it is undisputed that after appellant maintains that he was arrested, he gave a breath test before the statutory warnings were given to him. There is no dispute in this case that those statutory warnings were not given to him. Because of the case law, then, the question really boils down to whether the consent that he gave was voluntary. And most of the cases that have been cited by both sides on the brief, there's always a notation from the courts saying, well, evidence that the consent was not voluntary. And I believe that that is the issue here. But in this particular case, there were some unusual things that happened that do not necessarily happen in the ordinary course of a DWI arrest. The defendant was pulled over for some minor traffic violations, nothing aggravating.
But you're not questioning, or are you questioning whether or not the initial stop was improper?
We are not questioning the that the initial stop was proper, Your Honor. There was a video, and there could have been explanations for his erratic driving. The place where he was caught with the traffic violations wasn't very well lit, but speed was not a factor. And he was simply going from his house to an Allsup's convenience store.
There was evidence in the record, though, that when this consent search, or whatever you want to call it, took place, that took place in the police station instead of on the scene. Is that right?
That is correct, Your Honor.
Is it your contention that he was under arrest at that point? Or was he free to go? Or what does the record say about that?
Well, Your Honor, the record reflects that the officer initially stopped him as he's ordered him to come back to the vehicle as he's going inside the Allsup's convenience store. And when he comes back, Mr. Rodriguez is wondering why he got pulled over. He's got a 12-year-old child with him who is crying, and he is crying because he doesn't know what's going to happen. And just the sight of seeing the police officer talk to his father makes him cry, as reflected in the record. Very hard crying, doesn't know what to expect. He's wanting to make a phone call, and the officer is not making it. Because of that situation, the officer decides that he's going to take him to the police station. We're going to calm the kid down, get him out of the picture, and then he makes Mr. Rodriguez get into the vehicle. Is he free to go once he gets in the vehicle? Absolutely not.
Well, did you argue that in the brief, that he was under arrest? Or was your argument constrained to the transportation code argument?
That was not argued in the brief. What we did argue was that he was under arrest at the time, and I am detailing the facts that I believe show that he was under arrest and show that he was under some physical and pressure, as well as some psychological pressure because of what happened to his son, because he didn't understand why he was getting pulled over. And then he gets transported to the police department to actually do the field sobriety test.
You suggesting that influences the voluntariness of his consent?
Beg your pardon, Your Honor?
You say that influences the voluntariness of his consent or the lack of voluntariness?
I believe so, Your Honor. I mean, once he gets put in the car and it's taken to the police department to undergo field sobriety test, he's no longer free to go. There's no indication in the record that the officer at any time told him on the video or during his testimony that he was ever free to go. And so the issue becomes, we have the statute that says they have to do this. You have to give them these warnings. It doesn't say may or will, it says shall. And so Mr. Rodriguez Mendoza, he's undergoing some psychological pressure at seeing his son cry. He's now in a police station. There's nothing in the record that indicates that he's free to go. So he has to be in custody because of the fact that he is inside the investigation of the police department, and the investigation is now, at the time they get to the police station, the initial investigation is now about 15 minutes into the video, and then it keeps going for another 20 minutes before the officer tells him that if he would sign the consent form, but he's already given the breath test. He's already given the sample. I'd say that would be analogous to the requirement before the introduction of a breath test result that the operator has to acknowledge that he followed the procedural rules, such as the 15-minute observation time before acquiring the breath sample. That was done in this particular case.
At the hearing on the motion to suppress, did you argue that he was coerced?
Did I argue what?
Did you argue that he was coerced?
We did not argue coercion, Your Honor. We argued that it was not voluntary. The consent was not voluntary because of the circumstances of the case.
Okay. And the trial court did not issue findings of fact.
That is correct. There was no findings of facts requested, and the court did not issue any. It was believed that at that time that the issue of the consent had to be put into evidence, but by the defendant. But as per Section 3823 of the Texas Code of Criminal Procedure, but it doesn't have to be put on by a defendant. The evidence in this case with the video from the time of the stop at the Allsup's convenience store all the way to the intake at the police station, the field sobriety tests inside the police station show in appellant's position or contention that he was doing everything the police officer was telling him to do because he didn't know he had a choice. And those are the factors that the appellant would ask the court to consider in determining whether the consent was voluntary, because once that issue is placed.
Does the video indicate any dialogue between your client and the officer, other than you consent or whatever to take, to give a breathalyzer? Was there any exchanges, any
Your Honor,
small talk, anything along that line?
Your Honor, the dialogue in that video is very respectful both ways. My client is very respectful to the police officer. He doesn't ask the officer any questions, but he's answering all these questions. And there's no oral threats on the video by the police officer. There's no misinformation in the video by the police officer. He's simply asking him to do things, and he's doing what he's instructed to do, including.
Where's the child during all this? Where's the child during all this?
No, the child had been picked up at the scene by a relative, and so the child was no longer at the scene. And the child is not present at the police station.
I'm trying to understand. I understand your argument that the language shall means it's mandatory, but I'm trying to understand what the practical difference was with the fact that he didn't know beforehand, but then he signed the form after the fact. The statute itself under 724.015 says that the officer's got to provide the following information. There are 8 things that the officer's got to provide. The first 3 are consequences of if he refuses, which they're all things that can happen to you, can be used against you in court, et cetera. Well, he didn't refused, so I don't know that those are applicable at all. Number 4 talks about that if he submits, being over the age of 21, and his blood alcohol level falls within the concentration level specified under the penal code, then his license can be automatically suspended for not less than 90 days. Number 5 talks about if he's under 21, which doesn't apply. Number 6 is an officer determining that he's a resident without a license, which I don't think we've got applicable here. 7 talks about his right to a hearing on the suspension, which I don't know was really relevant. But then number 8 says if the person submits to the taking of a blood specimen, the specimen will be retained and preserved in accordance with Article 3850 of the Code of Criminal Procedure. So of the ones of what he submitted to, it seems to me like the only things he would have been told that are relevant here is, number 1, his license can be suspended, and number 2, we're going to handle your evidence in accordance with 3850. So given that he signed the consent after the fact, what is it that would require the suppression of the evidence other than just saying the problem was cured when he signed the consent?
Your Honor, one of the arguments that the state is making is the warning is only relevant to let the person know that if you do not consent, that evidence will be introduced against you. But they cited some supplemental cases yesterday, including Collins versus State, was a Court of Appeals case out of Dallas from July 30th of 2002.
You have the cite to that again?
The site is, it's not reported in Southwest 3rd. It says 2002 Westlaw 1752205. And in that case, Justice Dawes, the court says that when the defendant consents to the taking of the specimen, because the warning addresses only the consequences of specimen refusal, the state is incorrect. Subsections 3 and 4 of Section 724.015 concern situations in which a person submits to the taking of a specimen. And the court goes on to say, well, you know, this is kind of like when the cases where the officer gives more information than they're required, like tells them that, you know, it could go bad for you, or adds any other language to that section. And the court in Collins says that a causal connection between the improper warning and the decision to submit to a breath test. We're not talking about improper warnings here. We're talking about no warnings whatsoever.
Well, doesn't the Constitution provide, as far as unreasonable, prevention of unreasonable search and seizures, if you consent, that's an exception. And wouldn't his consent here prior to be enough?
Well, it's part of a, there's nothing in the record that states or suggests that he didn't know that was part of the standard field sobriety testing, Your Honor. I mean, he would say things like, you want me to do what? Yes. You want me to do this? Yes. There's nothing in the record that suggests that he was aware that he had a right to refuse. And not only a right to refuse, but he certainly did not know what the consequences were of a refusal if he's never been told at least the 3 requirements under subsection 724.15, as Justice Doss mentioned. But I think it's a requirement that was put there because of the same procedures that have been put into place in regards to the admissibility of breath test cases. I've seen many breath test cases that get thrown out just because there was not a mandatory 15-minute observation period. And of course, the courts have construed that 15-minute observation period doesn't have to start at the police station. It can start at the stop. So
I
That
guess
is
you're
the,
suggesting, counsel, that the consent or voluntariness is affected not only by mindset, he's inebriated, he's under pressure, his children were there, he's sitting in a police station, and the effect that has on his mind, but also knowledge that he did not know his rights, so to speak, or he did not know his right to refuse.
well, he had a right to refuse, and he didn't know that. He had a
You're
right.
saying there's two prongs to it. It's just not his mindset, it's also the information provided him.
I don't think this had anything to do with the state of his, whatever state of inebriation he was in, Your Honor, because if he had not consented, then maybe the state wouldn't have a case. But our argument is that if the law says that you have to, that they're required and that shall do this, I believe that the reason for that is so that the people have an informed consent to give consent and not just give consent just because they're asked to do so. I think the consent goes further than just doing what they tell you to do. Is informed consent is, and that's probably one of the things that counsel at trial on the hearing to suppress should have offered or argued more, was the fact that he gave consent, but it was not informed consent.
Well, was he able to consent, given that he blew a .211 and a .217?
If you look at the video, Your Honor, he doesn't look a .21. He's answering all the questions in the testimony in the record. I believe it's volume 4, page 30. When I'm going down the list of asking the officer, was he cooperative? Yes. Did he answer all your questions? Yes. Was he vulgar to you? No. Was he polite to you? Yes. Did he seem to understand everything he was asking? And the officer admits that he was understanding everything he asked him to do. So,
You're suggesting he had a sharp mind.
beg your pardon?
He had a sharp mind, even though he was inebriated.
Yeah, and you know, we don't, there's not sufficient information in the record regarding, you know, whether he had, you know, 3 or 4 or 4 or 5. The officer tried to get into that, but I cut him off as not being able to do that because it would require some form of a testimony regarding how much he'd had to drink and stuff like that. So the court cut him off.
Thank you, counsel. Any questions? Thank you, counsel.
Thank you.
5-minute rebuttal. Okay.
Good morning, Mr. Chief Justice. May it please the court, counsel. My name is Michaela Key, and I represent the state of Texas in today's case.
Can you pull your microphone a little bit closer or aim it toward you? Thank you.
Is that better?
Much.
There are actually 2 issues in today's case, not just one. The first is, like the appellant stated, whether the trial court properly denied the appellant's motion to suppress evidence of the intoxilizer results. And then the second is whether the Criminal Procedure Article 38.23, also known as the Texas Exclusionary Rule, applies when appellant was not read the statutory information of the Texas Transportation Code, Section 724.015, also known as the DIC 24 warnings, prior to being requested to provide a specimen. For the first issue, the trial court did properly deny appellant's motion to suppress because he voluntarily gave consent to provide a specimen of his breath to Officer John Torres. And for the second issue, there is no causal connection between the statutory noncompliance and the evidence obtained from appellant. The evidence of the intoxilizer results of appellant was admissible, and it did not trigger the application of the Texas Exclusionary Rule.
Why wasn't there any causal connection in your view?
Well,
You agree that there was no compliance with the statute beforehand, correct?
Yes, Your Honor. I mean, there's no dispute on that. As the appellant stated, the Officer Torres did not read the DIC 24 warnings prior to requesting the breath specimen from appellant and administering the test.
If he had refused to sign the form after the fact, would you have a problem on admissibility of the test results?
I'm sorry, what was the last part?
If he had refused to sign the DIC 24S after the fact, would you have a problem on the admissibility of those results?
There may be, but under that, it would have to still be a ruling to show that under the totality of the circumstances, whether or not the court would find that the facts indicate that if there is a causal connection, the appellant would have changed his decision on that. And the facts here show, given that there is consent here, the facts show that there was Officer Torres during the suppression hearing. He directly testified that he did not directly or indirectly promise the appellant anything in exchange for that consent. He did not coerce or threaten the appellant into giving consent. And the record establishes from both the suppression hearing and the trial, the appellant freely and voluntarily complied with everything requested of him by Officer Torres.
Was he already under arrest at that point?
No, he
Being
was
told to get in the
not.
police car and taken to the station?
No, he was not. And that's shown just from, this was a DWI investigation. As appellant stated during his argument, the officer made the choice to remove the appellant from the area that he was first pulled over because of how his son was acting, and just given the area it was in front of an Allsups, they needed to go somewhere quieter to continue the DWI investigation. And this is also shown that the
Does it
jail...
matter that the quieter part was police department?
Police department, but the jail is not even located in the police department at this facility. So he was not under arrest. It was just standard police procedure.
Was he free to go?
At that point, he is being detained to ensure that he is safe to drive. And this is standard police conduct when they're conducting a driving while intoxicated investigation. He needed to have him perform the field sobriety test to see if he had the coordinated mental and physical functions in order to be able to continue driving in a safe manner within the community.
So he wasn't free to go if he was being detained.
Yes, Your Honor.
Is there a difference between being in custody and being detained?
Being detained, you're not under arrest for any criminal charges. Therefore, you're not required to have your Miranda warnings. There's just an investigation to make sure that the safety of the community is not being jeopardized on that.
Why not just stop and get a warrant at that point?
For the same reasons as that there's the jeopardy of the safety of the community. If you allow someone to just give them a warning and then allow them to go back into their vehicle and continue driving, and they are unfit to be driving in a public roadway, that could jeopardize the community. And if you're driving while intoxicated at whatever level it's determined later, that could cause accidents and physical injuries to others within the community, along with the person that is being investigated as well. And here, the appellant freely consented to all those field sobriety tests in the police station. He stated yes, he never stated no to that. And additionally,
Did they ever
before,
tell him that he didn't have to consent to any of this?
the police is not required to provide that
They were
information.
required to admonish him before taking a breathalyzer, and they didn't do that either.
No, they did not. But the police are not required to give in any search or seizure, police are not required to tell an individual that they have the right to refuse a test or a search or a seizure.
Well, if he was under arrest, they would have to Mirandize him and tell him of his rights against self-incrimination, though, right?
Absolutely. And in this case, the officer did read him his Miranda warnings before requesting a breath specimen, even though he didn't read the DIC 24 to him until after he had consented to that breath specimen. But under the totality of the circumstances, and the record clearly establishes that.
Was reading a Miranda right some indicia that maybe he was under arrest? Do you read people who aren't under arrest their Miranda rights?
I believe it's just a safety precaution that this officer did, but it doesn't.
But is that an indicia that can be considered whether or not he was under arrest?
It can be considered that. But with this fact scenario, he was not under arrest until after he gave the breath specimen. Did that answer your question? So, as I stated earlier, the police aren't required to give a warning of an individual that he has the right to refuse to give any sort of test. And that's shown in Schlecknock versus Bustamante. That is the United States Supreme Court.
Let's talk about the statute. The statute says shall. Do you agree it's mandatory, or do you disagree it's mandatory?
It is it's the police officer is required to give those warnings. But the purpose of the statute and the officer's noncompliance with that statute, according to the Texas exclusionary rule, is not sufficiently related to the evidence that was obtained.
Why?
So since the appellant voluntarily consented to that, and the appellant has not shown that there's been a causal connection between that noncompliance of that statute and the evidence
You think
obtained.
if he was told for the statute that if you blow whatever, what is it, 0.08, you're going to have your license taken away, that could or could not influence his decision on whether or not to take a breathalyzer?
The record does not establish that.
I'm asking
here.
you. The first, Justice Doss mentioned the first three requirements, and they discussed the effects of you failing a breathalyzer test or other things.
They discuss the effects of refusing.
Refusing. The fourth tells you what happens if you do fail a breathalyzer test. You lose your license. Why wouldn't that be influential to somebody who's being asked to take a breathalyzer test?
I mean, if
Kind of
you,
a Hobson's choice. If I don't, I get in trouble. If I do, I get in trouble.
if you look at all of those warnings, all 8 of them, they're all indicating what would happen if you refuse, mostly
Not
when.
number 4.
I'm sorry?
Not number 4.
Not number 4, but if you read all of those, it seems to almost nudge someone to consent to this, is what this appellant did. He didn't refuse, he consented to that. And like you said earlier, if he had refused, it might have been different. But here, he consented to that without hearing any of those warnings. So if the warnings had been read to him, if anything, it would have marginally increased the likelihood that he would have consented to the breath specimen or even a blood specimen if he was requested of that. And the purpose of that Texas exclusionary rule is to prohibit law enforcement from overzealously procuring evidence from appellants. And since the defendant was the moving party and wishing to exclude this
That kind of
evidence.
contradicts what you just said. You said the statute kind of pushes him to give consent, which would suggest maybe a bit of overzealousness on the part of the state. We want you to give this breath test. So it just seems contradictory when you're saying it's not overzealous.
Well, for the Fourth Amendment protects, the Fourth Amendment protects you from an individual from any illegal obtainment of your property, liberty, or person. And the exclusionary rule is just a way to remedy that when an officer violates those. The DIC 24 warnings are administrative in nature. Their purpose is not to protect somebody from overzealous law enforcement obtaining a breath specimen. It's more of to provide notice requirements, such as with number 5 and number 6, and even number 4. It was from House Bill 63 in 2001 and Senate Bill 35 in 1997 that they noticed that there was an issue with the people that were being investigated for a driving while intoxicated offenses, and that they need to be provided notice. And then we look at number 3, where it says if a person refuses to submit the taking of a specimen, the officer may apply for a warrant authorizing a specimen to be taken from that person. I mean, the purpose of adding that into the DIC 24 wasn't to protect the arrestee or the person being investigated. It was actually because there was concern, if you look at the bill analysis of SB 1787, there is concern that informing a person that a refusal to submit to the taking of a specimen may result in the officer applying for a warrant authorizing the taking of that specimen constitutes coercion on the part of the informing officer. This bill seeks to remedy the issue by adding that to the information that an officer under those circumstances is required to provide before requesting that the person submit to the taking of a specimen. So that's actually protecting the officer from being accused of any type of coercion, because the case precedent has shown that if you add extra statutory warnings and the person refuses or consents, it can lead, under the totality of the circumstances review, that consent was involuntarily made because there's additional statutory warnings. But when you add those in there, the notice requirements, the fact that he can apply for a warrant if you refuse, that helps take that type of litigation out on future cases. So the
By
DIC...
omitting the warnings, if I'm following your argument correct, and if I'm not, please let me know. It's early in the morning, it's not quite lunch yet, but sometimes I'm a little slow. But by following your argument, if you do not give those warnings, then that could be used as an indicia of non-consent?
I'm sorry, what was the last part?
If you do not give those warnings, that could be used as an indicia to argue non-consent, because we want to protect the officer and make sure the officer tells them everything so they can't say, I did not consent?
Yes, and that was seen in...
So that's another thing, since the officer didn't give him here, that's something else that can be weighed in favor of a decision. He really wasn't consenting to this?
if he's given extra statutory warnings or not given those warnings at all.
Those warnings. These warnings in the statute.
I'm sorry. So you're saying that because he hadn't been given those warnings, that it shows that the consent was involuntary?
Well, I'm just trying to figure out the tenor of your argument, and maybe I misunderstood it, but that's okay. I don't want to take away from your time, so.
Well,
Your argument is that the reason why we've got the amendment to the statute is essentially to wire around a problem where a would-be defendant or a suspect accused of DWI refuses to consent, and the officer then saying, aha, you refuse to consent, that must show that you're intoxicated, so I'm going to use that as a basis for getting a warrant, right?
Well, I mean-
The purpose of the statute is, you say it's to protect the officer. I don't know that I agree with that part, but it's to wire around that problem so that the defendant can't make that argument in the future.
well, it was enacted because there were a lot of litigation over that when an individual states that they refuse, and then an officer later tells them that, well, I can apply for a warrant, and then, so let's see.
To me, here's why I'm asking that. So suppose your officer had taken the defendant to the station, and the defendant just refuses to do anything. We've already said now we can debate whether he was there because he was under arrest or it was for protective purposes or something else. But what happens at that point? He's now inside the station. Do they say, too bad, now we're going to get a warrant and we're going to draw your blood, or we're going to let you walk out the door now because you've consented, you've refused to consent?
So you're saying because he was in the police station, that if he had refused, the officer, it wouldn't have mattered?
I guess I'm speculating about what would happen next, but it was really in response to your statement that that new provision in the statute was intended to protect the officer from preventing these situations from coming up where these defendants say, you know what, you used my refusal to submit as the reason for why you needed to get the warrant.
No, what I'm saying is basically what happened in Feenan versus State. That was where it was a DWI investigation, and a state trooper, provided the warnings and the DIC-24 in that case. And after he had been read all of those under the statute of 724.015, the defendant in there refused. And so during that time, the defendant was sitting in the patrol car. And after the refusal, the trooper then calls into dispatch and says, I need the judge to come meet me at the hospital because there's a refusal to look at a warrant and to get a blood draw. The defendant overheard that and then changed his mind. And after he asked, then you can get a warrant. And the officer was answering that, per the statute, you can get a warrant if someone refuses. And so they changed their mind. And then later, after answering a couple more questions that were completely within the trooper's right, they were based on codified law, they were not misleading in any way, then the defendant changed it back to consenting and ended up consenting to a breast specimen.
Understood, I'm sorry.
So that takes that out because the officer was doing their job. They were being professional. That's where number 3 in the DIC-24 warnings comes into. When an officer is just doing their job and giving the defendant or the arrestee that's being investigated the correct information under statute. And it's just plain saying that there's no coercion in these specific cases. And here there was no coercion shown within the record. There was no direct testimony from appellant during the suppression hearing, so we did not see whether or not the appellant, if he would have had the DIC-24 warnings, he would have had a different decision and whether or not he would have consented or refused. None of that was provided there. The trial court found, based on the facts presented during the suppression hearing and then also during the trial, that there was no coercion on the part of Officer John Torres. And since there was no coercion, the state met its burden on the totality of the circumstances showing that the consent was voluntarily made. Then the burden switched over to appellant to show that there was a causal connection between that voluntary consent and the exclusionary rule, or that voluntary consent of the evidence and the violation of that noncompliance of the statute, and there was none shown. And for those reasons, we request that you reaffirm the trial court's ruling.
Thank you, counsel. Butler, sir? If you have a cell phone, please turn it on mute. And if that's not a cell phone, if you can catch that canary that whistled, I'd appreciate it.
My police court, in closing, the appellant would just like to point out a few things that are in the record regarding what the appellant is saying, that there was certainly physical and psychological pressure on volume 4 of the reporter's record, page 18, when the officer's first talking to Mr. Rodriguez Mendoza, the officer says, you said you were speaking to him. What was his demeanor like while you were speaking to him?
Can you turn the microphone a little bit closer to you, please?
And the officer
Now,
says,
is this at trial or is this at the hearing on the motion to suppress?
I believe this was at the trial, Your Honor.
Well, aren't we looking at the evidence that was presented at the motion to suppress hearing?
I believe this was the if I'm correct, the volume 4 of the reporter's record would not have been part of the hearing on suppression, but it clarifies some of the things we're saying about the appellant having been under physical pressure because he has one officer there, his son is hysterically crying, then he calls another police officer.
Well, wasn't that evidence, that went towards getting him a light punishment? It wasn't for the suppression of the evidence.
Well, I mean, he did get a light punishment, but I think it reflects in appellant's counsel's brief in reviewing the record. Those were things that reflect the physical pressure that some of these cases cite. The testimony doesn't have to come from the defendants. And in this case, it didn't come from the defendant. It came from the overall procedural of how the arrest took place.
Judge Parker raised a good question. In reviewing this, are we restricted to the record that was developed during the suppression hearing, or can we look at that as well as evidence that was developed at trial?
Your Honor, I believe that the court is free to look at the entire record because it's on a case-by-case basis, and it's not limited to what the evidence shows at the suppression hearing, because the same video, I believe, was also played in the trial of the case.
Well, then the trial court would never have an opportunity to correct, in this instance, his erroneous ruling.
Well, the trial court,
Alleged erroneous ruling.
Well, under his facts.
the trial court was very limited, I believe, in not, because he consented and maybe not having had the opportunity to review the entire video, but
What about the issue of, that the state's attorney brought up just a minute ago, that although there may not have been compliance with this statutory provision before the test occurred, your client did receive his Miranda warnings before the test took place. Wouldn't that work against your client's position of saying that his will was somehow overcome and that he didn't have consent?
well, I don't know if the record reflects, either at the motion to suppress hearing, that even occurred.
Well, okay, so if we restrict that to the motion to suppress hearing, don't we also have to restrict the other evidence to what came up in the motion to suppress hearing, as Justice Parker was mentioning just a
Well,
minute ago?
yes, but the Miranda warnings would counter their argument that my client was not under, that the appellant was not under arrest. If it's in the record on the motion to suppress that he was Mirandized, or I think the record only says something about constitutional rights. It doesn't necessarily say there was some Miranda rights. But that position would go to show that there's no question that when appellant was taken from the Officer's Convenience Store to the Freona Police Department, he was under arrest.
You were going to say, before I interrupted you with the question, you were referring us to volume 4, page 18.
That's
Yeah, so tell me.
To reiterate what happened when the officer pulls him over, and my client doesn't know what's going on. And at some point in time, he even tells the officer he didn't know he was intoxicated. And I was trying to find out why the child started crying hysterically as soon as he got pulled over. And I asked the officer, could that be because she knew, the 12-year-old knew that you were going to arrest his father at the scene? And he finally stated that possibly that could have been the reason that the 12-year-old was crying.
Anything else? Thank you, counsel. Your time
Thank you.
expired. The case is submitted and you are free to go. You finished your first oral argument. Thank you very much. Hopefully it wasn't as painful as you may have thought it would have been, but we look forward to seeing both attorneys in our court in the future. Thank you.
back at 15?
We're going to be in recess for about 7 minutes, 6, 7 minutes. Change panel.